My name is Alan Medlin, and I'm a professor at the University of South Carolina School of Law, which hosts the student editorial board of the journal. At this time, Professor Amy Milligan of our law school is the professional editor-in-chief of the journal. The journal has been at our law school for over 30 years, and we greatly appreciate the relationship with the ABA and the section. My colleague and co-author on this article and many other projects is Professor Boyle, whose expertise includes estate and gift taxation and fiduciary income taxation. One of our collaborative projects is the Probate Practice Reporter, which we have edited and written since 1989. The genesis of this article, Creditors' Rights and Property Subject to a Beneficiary's Right of Withdrawal, comes from Professor Boyle's extensive research in those areas of taxation. Many times, estate planning employs the use of powers of appointment, giving a beneficiary the right to appoint trust property to recipients. These powers of appointment, such as Crummey powers and so-called 505 powers, are typically restricted to avoid adverse tax consequences, yet provide some ability for the beneficiary to use the appointed property personally. However, when a beneficiary has such a power, creditors of that beneficiary may claim the right to reach the property subject to the power while the property is still in trust. In producing the Probate Practice Reporter over the years, Professor Boyle and I try to read every reported probate decision each month. In that review, we have noticed that state law treatment of creditors' rights for these tax-related powers tend to vary among the jurisdictions. We thought a journal article reviewing the tax reasons for these limited powers and the varying state law treatment of creditors' rights for those powers would be helpful to journal readers. We also discussed some planning techniques that might address the creditors' rights issue. We hope this article is helpful. Thank you.